Turning now to more pro-life news, a federal appeals court panel recently upheld a Louisiana law requiring basic safety standards in abortion clinics. The 2014 law requires abortionists have admitting privileges at a nearby hospital in case of an emergency. A panel at the 5th U.S. Circuit Court of Appeals upheld the legislation in a 2-to-1 vote last month, distinguishing it from a Texas law that was struck down at the Supreme Court. Our next guest has been on the forefront of this ongoing legal challenge. Joining us now from Baton Rouge, Louisiana, is Louisiana's Attorney General, Jeff Landry. Thank you so much for your time.
Thank you for having me.
First off, can you explain exactly what Act 620 requires?
Yeah, so what Act 620 did was basically make admitting privileges uniform across the state of Louisiana. So at any outpatient center, any ambulatory center, the doctor was required to have admitting privileges. That was true before 620, except there was an exception for abortion clinics. And so all we did was, the legislature did, was just make it uniform throughout Louisiana so that at outpatient centers, ambulatory centers, the doctors were required to have admitting privileges to hospitals.
And can you explain why was it challenged in the first place?
Well, because again, we see those pro-abortion forces around the country always trying to single out little bitty things in an effort to hold on to their particular stance on abortion. And this was really not about abortion clinics. This was about women's health. This was about ensuring that we had a uniform set of rules that governed outpatient centers all across Louisiana. So whether a woman walked into a clinic to have her tonsils taken out, the doctor there would be required to have admitting privileges. And so in abortion clinics in Louisiana, we said that those doctors would have to have admitting privileges as well.
Now, the Supreme Court in 2016 struck down a Texas admitting privileges law. What differentiates the Texas law from the Louisiana one?
Well, the Texas law was patently different than Louisiana's law. In Texas didn't have a law that where basically they regulated ambulatory centers, where they outpatient centers, where they required doctors to have admitting privileges. So they went out and specifically targeted abortion clinics. It was actually the reverse here in Louisiana. So in Louisiana, again, outpatient centers required admitting privileges except for abortion clinics. And so what Louisiana's law did was, again, Act 620 did, was make it uniform. And so that's why we believe that our law is constitutional.
You hit on this a bit earlier, but can you explain why are admitting privilege laws in the interest of patient health and safety? And do these laws benefit women as well as unborn children?
Well, it certainly benefits women's health. I mean, think about this. If you go down to the doctor to have a small sinus operation or some procedure which requires sedation, okay, then in Louisiana, that doctor would be required to have an admitting privilege, because if something goes wrong in that particular procedure, you would want him to be able to admit you to the nearest hospital in case there is a life-threatening issue that comes up during that procedure. And so again, here in Louisiana, what we did was we made it uniform so that whether it's at any outpatient center, any ambulatory center, is going to require that doctor to have admitting privileges. And that's in the best interest of women's health.
And if such laws are in the interest of the woman's health and safety, what's been your reaction to abortion advocates really objecting to them?
Well, I find it to be hypocritical because, again, wouldn't you, again, abortion advocates out there go out and they claim that it's all about women's health. Well, Louisiana's law protects women's health. It ensures that there is a uniform application for women whether they go into any type of procedure that requires heavy sedation. So again, they should not be treated differently if they're going to get an abortion or whether they're going to get their tonsils or adenoids taken out.
Act 620 has been upheld. Are you expecting any more pushback or opposition in the future to it?
Well, currently, right now, in the June medical case, they are actually taking the ruling by the Fifth Circuit panel and asking for an en banc hearing. So again, we still haven't finished all of the legal procedures at the appeals level, but we're hoping that that the Fifth Circuit will deny the en banc hearing and uphold the panel's decision.
And finally, you yourself have been very outspoken about your pro-life views. Can you explain here in our program, why are you pro-life?
Well, again, look, I was always raised to respect life, right, in order to protect and preserve life. And I made no bones about it, whether I was serving in the U.S. Congress or as the Attorney General. In this particular instance, I'm out there ensuring that we uphold the will of the Louisiana legislature.
Jeff Landry, Louisiana Attorney General, thank you so much for your time today.
Thank you.